All right, good morning. We're back for part 2 on this landlord-tenant eviction dispute. If you didn't catch my live stream from August 23rd, 2 days ago, go back and watch part 1 first. I'm going to give you a quick recap, but this probably isn't going to make sense if you haven't watched part 1. So go back and do that. But to give you just an update of where we've been to get us to this point, today I'm going to go over the final judgment. We're going to talk about the trial. We're going to go over the final judgment in this case. In part 1, which is why you need to watch it, we went through the facts of the case and the claims on both sides. So we went through the original complaint. If you recall, this was a claim for both eviction of a tenant and damages in the form of unpaid rent. The complaint was later amended to drop the eviction count because the tenant moved out on her own during the pendency of this lawsuit. And we added a claim for the security deposit because she hadn't paid her rent and there were physical damages to the property. The tenant filed a counterclaim against landlord. Her counterclaim was for number 1, breach of the lease. If you recall, this was a 1-year lease. At the end of the lease, there was an addendum that stated at the end of the 1 year, the parties agree to sign a new lease for an additional year at the same terms. That never happened for reasons we're going to talk about today. And so that forms the basis for the tenant's counterclaim against the landlord for breach of the lease. Since no second lease was signed, she said that was a breach of the lease agreement. And the result of that, she ended up testifying, was that she was unable to utilize the amenities in the community, and she had to go through the guest line at the gate to enter the community versus the resident line. Count 2 of her counterclaim was for return of the security deposit to her. So there are competing claims for the $5,000 security deposit. And that is where we ended part 1, which again, August 23rd, part 1 of this live stream. Make sure you go back and watch that so you know what we're talking about when we go through the final judgment today. So that's where we left off on part 1. This case was filed, I believe, August of 2022. It went to trial in July of 2023. So almost a year later. That is a long amount of time for an eviction case. This case was a bit different because the tenant did move out in February of this year. So that kind of urgency and time sensitivity of getting the tenant out so the landlord could start collecting rent again went away as of February. But a year is a pretty good amount of time for an eviction case. I went on vacation in Hawaii in June of this year. I get back and the court had unilaterally scheduled the trial for July 18th. And I think we got notice. We got notice 12 days before that. So what was that, July 6th? I don't know. I think that was the day I returned from vacation. I get a notice of trial that we're going to trial 4 hours away from where I live with 12 days notice. So that was my welcome home from Hawaii. But we prepared, we got it done. I traveled down. Hello, thanks for joining me. Let me know if you have any questions, thoughts, comments in the chat. Happy to go through those with you. And I always forget to mention, that's why I'm doing live streams. So we can have a back and forth, so I can answer your questions, so we can chat it out and nerd out together on these cases. So let me know your thoughts in the comments or in the chat. So I book a flight, I get a hotel, I get down to trial, and the morning of trial, it was an afternoon trial. The morning of trial, my assistant called the judicial assistant to just confirm everything for the trial. And the judge herself answered the phone, and she's like, well, this is Zoom. And my assistant's like, well, my attorney's there in person, so can she come in person anyway? And the judge was like, yes, but she was clearly annoyed with me. So that's how that's the foot we started off on with regard to the trial. So the trial was held in the judge's chambers versus in the courtroom. So a little bit of close quarters. The only witnesses there testifying were my client, who was the landlord, and then the defendant. There's actually 2 defendants. Only one of the defendants showed up. That's very, very odd. Counsel for the defendants didn't really have an answer to the judge when she said, "Where's your other client?" Definitely odd. But so only 2 witnesses were in chambers. The judge starts out and she's like, "You know what? I do things a little bit differently here." And my anxious brain is already saying, "Oh goodness," because when I prepare for trial, I am organized to a T. Like I have a separate binder for each item. So I have like evidence binders, I have case law binders, I have my binder with the pleadings, I have my binder with the testimony and cross examinations and my arguments, all of those things. And I have binders for everyone in the courtroom, for the witnesses, for opposing counsel, for the judge. And the judge is like, "I don't want binders. Take everything out of binders." And I'm panicking because my organizational system works. I use it every time I go to trial. It works beautifully. It's so seamless when you're entering evidence. And the judge was like, "I don't care. Take everything out of your binders." So I'm literally sitting there like, I probably have 10 binders and I'm shuffling all the papers, and you have to bring 4 copies of everything. So I have to do everything 4 times as far as taking everything out of the binders and passing it out. It was stressful, to say the least. And then the judge was like, "Just do your opening on one topic. I just want to hear about this one thing. And then you can call your witness on that topic. Opposing counsel can cross-examine on that topic. And then we'll start again with topic number 2. And then you'll do your opening on that topic and question your witnesses on that topic." And I'm just like, what? Like, this is going to take forever. And I got a flight to catch tonight. Like, what? So you just got to go with the flow at trial. Different judges have different ways that they like to do things. They have different preferences and procedures. And some of those procedures are posted online, so you're aware of them and you can comply with them up front. Some of them aren't. In this case, none of this was available to me prior to trial. So a lot of litigation work is kind of doing things on the fly and going with the flow and thinking on your feet. So it makes it fun, but also stressful. So we get through the trial. I will go through some of the evidence, the specific evidence, as we go through the final judgment together, because I think it will make more sense. So let me go ahead and pull up that final judgment for you so you can see what I'm talking about here. All right. So this is the final judgment. Sometimes judges rule at the trial itself, which was July 18th. This judge said, "Hey, I'm going to reserve ruling. I will have a decision out to you within 30 days. Literally at 7:00 at night on day 30 is when she filed this final judgment. So she made us wait that entire 30 days, which was brutal, but we got it and here it is. So let's go through it. All right, this cause having come on before the court for trial on July 18th, 2023 on plaintiff Miguel Tamarit and Miguel Tamarit's first amended complaint and the defendants Todd Cohen, who was not at trial, and Stacey Hood's amended counterclaim. The court, after having taken testimony and after having reviewed the evidence admitted and being otherwise fully advised in the premises, the court finds and decides as follows. So this is where we're going to get into the meat of the court's ruling. As to count 1 of the first amended complaint, so this was our claim for the security deposit. The tenant paid a $5,000 security deposit pursuant to the lease. After she moved out of the premises, we amended our complaint to add a claim against the security deposit for multiple reasons. Number 1 is there was physical damage to the property. Number 2, the plaintiff was about $29,000 behind in rent. So that was the second basis. The court finds that the notice given on the notice of claim to the security deposit was timely. So this was a big issue at trial. When a landlord is going to impose a claim on a security deposit, whether they're going to keep the whole security deposit or just a portion of that security deposit, Florida law provides, the statute provides, that a landlord has 30 days from the date the tenant vacates the property. And vacate, that is the word that the statute uses, and that's going to become very important for purposes of this discussion. So a landlord has 30 days from the date the tenant vacates to send out a notice to the tenant advising the tenant that this is the amount the landlord intends to withhold from the security deposit and why they're withholding that amount. You should provide, as a landlord, you should provide an itemized list of the damage or whatever reasons the landlord has for withholding that amount. In this case, if you recall, the first lease ended February of 2022. The addendum to the lease said that the parties agreed to sign a second lease for an additional year ending February 4th of 2023. That lease was never signed. Regardless of that fact, the defendant decided that she was still going to stay in the property, even though she didn't have a lease. So she stayed for that second year, even though there was no lease. Had there been a lease, it would have ended February 4th, 2023. So February 4th comes and goes, and my office reaches out to the defendant's lawyer. At this point, we're already in litigation. Both parties have lawyers. And I say, hey, is your client out of the property? What's going on? My client wants to go in and retake possession if she's moved out, but we need to make sure she's moved out. And he's like, I don't know, I'll get back to you. And I'm like, okay. So a week or two later, I follow up and I'm like, hey, has your client moved out? What's going on here? And he's like, I think she has, but let me check. I don't hear anything back. And on February 19th, the lawyer does respond and says, I'm going to overnight the keys. My client's moved out. I'm going to overnight the keys to your client, which he does. And there is a FedEx label dated February 19th of 2023 where he's overnighting the keys. And I of course, have the email where we are first notified that the tenant has moved out of the property on February 19th. So we calculate 30 days from February 19th so that we can calendar our deadline to get that notice of intention to claim security deposit out to the tenant in a timely manner. I might be getting the dates mixed up, but I think on March 16th, we sent out the notice. So within the 30-day time frame, if we're starting that time period from February the 19th. Well, at trial, the defense attorney argues, well, my client was out even before February 4th when the lease would have ended. And so their notice dated March 16th is not timely. And if the notice isn't timely, the landlord doesn't get the security deposit. That's clear. No argument there. And so he calls his client, the tenant, to testify as to this issue. And this is where it gets a little bit wild, or a little bit more wild than it already's been. So he asked, when did you move out of the property? And she's like, oh, well, I don't really remember. Okay. Your whole defense that we're not entitled to the security deposit is based on it was late because you moved out prior to February 4th. But you're sitting here at trial saying you don't remember when you moved out. Did they have a document to show when she moved out, to prove when she moved out? Nope, they sure didn't. So he concludes his examination, his direct examination of the tenant, and the judge starts asking her questions. And the judge asks her again, do you remember when you moved out? She's like, no, but I think it was in January. It was definitely before February 4th. But I don't remember what day. And the judge was just like, okay, well, did you hire movers when you moved out? And she's like, yeah, I did. And the judge is like, well, did you pay the movers? And the tenant responds, yes, I paid the movers. And the judge is like, well, can you look up the date of payment that you paid the movers? Because that's going to be great evidence of the day that you moved out. Typically, the date you pay the movers is the day of the move. And the tenant is like, wow, that's a great idea. Let me look. And so she's looking through her phone, trying to find out, looking through her Venmo. And I'm just sitting there like they've showed up to court with no evidence. And she's now sitting there on her phone trying to find evidence. But okay. She can't find when she paid the movers. And the judge is like, okay, well, did you turn off the electric service when you moved out? And the tenant's like, yeah, I did. And the judge is like, well, why don't you look up on your account? I don't know what it's called down there in Fort Lauderdale. In Tampa, we call it Tico, whatever electric company. She's like, pull up so-and-so electric company, look at your account and see when you shut off the electricity, because that would be great evidence of when you moved out. And the tenant's like, that's a great idea. So she gets on her phone again and she's trying to get into her account, and we're sitting there and 5 minutes go by and 10 minutes go by. And we're like, okay, she can't find it. And the judge is like, would it be easier for you to sit at my desk and use my laptop to pull up the account with the electric company to look up when you turned off the electric? And I'm sitting here just trying to control my face, which I'm not very good at, but I'm trying hard. And I look at the judge's desk, which we're sitting in front of the judge. So we can't see her laptop screen. We can't see her papers, but she's been taking notes. She has evidence and exhibits just all sprawled out on her desk. And she gets out of her seat and she allows the defendant in the case to sit at her desk and get on her computer to use the internet to pull up her account with the electric company. And I'm just sitting there. I don't even know what to think at this point. I've never seen anything like this in my career as a litigator for almost 14 years. So she's finally able to pull up her account. And she's like, well, the last payment I made was on so-and-so date, but she couldn't find the date that the electricity was turned off. So the tenant, gets out of the judge's chair and goes and sits back down in the witness chair. And the judge is like, well, so the tenant had taken a video of the property with the property vacant. All the furniture was out, and the tenant took a video and was like, look what great condition I left it in. And that was above my objection, entered in as evidence. And the basis of my objection for that was I asked in cross-examination, I asked the tenant, on what date did you take this video? Well, I don't remember. Okay. And so when they asked to enter the video into evidence, the judge said, is there any objection? And I said, yes. I said, we don't know when this video was taken. It could have been taken 3 years ago. It could have been taken, at any point in time. We don't know if this is an accurate representation of the property from when she moved out. And the judge is like, well, the property's empty. So this was obviously after she moved out. And the tenant said she took it after she moved out. So why does the date really matter? And I'm thinking, well, because the rules of evidence says it matters. And that's how you authenticate a piece of evidence before it can be entered. But I just restate my position that I believe the date the date the video was taken matters, because we need the condition of the property on that date. And the judge is like, well, I'm admitting it over your objection, which, okay, fine, no worries. So the judge is like, can you look up on your phone when you took that video? Because that would be a good indication of the date that you moved out. And the tenant's like, yeah, I took it on my camera roll. I can look it up. So she's on her phone again. And at this point, I'm realizing this is taking so long. I'm going to miss my flight. I have a huge depot back in Tampa in person the very next morning. I can't reschedule it. I can't miss it. It's a big case. And so I'm like, oh my gosh, this is just absolutely nuts. I'm going to miss my flight. I don't even know how well this trial is going. But so the tenant is scrolling through, we're in July. This video was presumably taken sometime in February or maybe even January. So she's having to scroll a significant way. She apparently has lots of photos on her camera roll. And the judge gets out of her seat and is standing behind the tenant's shoulder, watching the tenant scroll through her photos in her phone. And when the tenant pulls up her camera roll, apparently the tenant had done a get ready with me video prior to going to court that day. And the judge sees it and she's like, oh, that's you. And the tenant's like, yeah, this is my get ready with me before I came here today. And I'm just like, what is happening right now? So she scrolls and scrolls and scrolls. It's literally 20 minutes. I'm not exaggerating to make a point. It's literally 20 minutes and she can't find it. So at the end of the day, the defense was unable to come forth with any sort of evidence as to the day the tenant moved out, which their whole argument is that my notice was late. And the 30-day deadline starts when the tenant vacates, and they had no idea when the tenant vacated. So in cross-examination, I pull up the email from defense counsel dated February 19th, And I insert that into evidence as this is the first time that we, the landlord or his counsel, were notified that the tenant had moved out. Defense counsel argued, well, possession or notification is not what the statute says as far as when that 30-day period starts to run. It's from when the tenant vacates. So my rebuttal to that argument was, Judge, the tenant, let's use defendant's argument in this text of an example. The defendant could have moved out on February 4th of 2023. They could have waited until April to notify me that she moved out or to notify my client that she moved out. And at that point, if we believe, or if we go with the tenant's argument, at that point, the 30-day deadline for the landlord to impose a claim on the security deposit has come and gone. She vacates February 4th, doesn't notify the landlord until April 1st. So if we adopt his argument, the tenant could completely remove my client's right to impose a claim on the security deposit by just waiting more than 30 days to notify him before he moves out. So when we look at the final judgment here, that was a long way to explain the first sentence of the final judgment. I promise we're going to be moving faster than that as we go along here. But when we look here, the court ruled that the notice given was timely. So the court agreed with my argument that you cannot start that 30-day clock until notice is given from tenant to landlord that the tenant has vacated. Now, this is this judge's interpretation of the statute. The statute says vacate. It doesn't say anything about notice. It doesn't say anything about returning the keys and actually turning possession over to the landlord. But we prevailed on that issue that the notice was timely. The judge continues in her ruling. However, as to the late fees and other non-rent items listed in paragraph 26 of the amended complaint, with the exception of $1,170.49 for the refrigerator repair, the court finds that the plaintiffs have failed to prove by a preponderance of the evidence any entitlement to the security deposit on those bases. The issue of the rent claim part of the notice of claim will be discussed infra. So part of our security deposit claim was failure to pay rent, which she's giving us, late fees, which she's not granting, and other non-rent items, so interest and things like that, she's not granting. We also claimed about $3,500 in physical damages to the property. And of that $3,500, the court is only awarding us $1,170.49. I will admit some of the physical damages that we were asking the court to grant could have been normal wear and tear. But if you're going to ask for anything, you might as well ask for all of it and let the judge decide. So that's what we did. So of the $3,500 in damages, physical damages to the property, we were awarded $1,170.49 on count 1 of the amended complaint. As to count 2 of the first amended complaint for damages, the court finds that the plaintiffs have been damaged in the sum of $2,814.98. Now, this is a bit confusing as far as how the judge set up this portion of her ruling. So she says this sum represents the amount that the court has determined that the plaintiffs are owed as rent, $18,333.37, less the funds that have been placed in the court registry, which is $16,688.88. The difference of which is $1644.49, which has not been paid by the defendants into the court registry, along with the amount of $1,170.49 for the repair of the refrigerator. All right, let's break this down. So once we filed this lawsuit, that triggered a requirement that the tenant deposit all of the disputed rent into the registry of the court, which she did. So sitting in the court registry at the time of trial is rent payments totaling $16,688.88. The judge is determining that the total rent amount the landlord is entitled to is $18,333.37. When you subtract the amount, the $16,688 that's already in the court registry, that's where we get this $1644 difference. So the full judgment is for the 18,333, but the amount the tenant actually has to come out of pocket for rent is only 1644 because she's already paid 16,688 of it. Hopefully that makes sense. In addition, the judge awarded us damages that we saw in the first paragraph for damage to the refrigerator of $11.70.49. So the total out of pocket the tenant has to pay is $28.14.98. Although the total amount of the judgment is $18,333 plus the $11.70. Okay. Hopefully you all are following me there. All right, the issue of the court's determination of the amount of rent owed to the plaintiffs will be discussed further infra in the court's ruling as to the counterclaim herein. The court further finds that the plaintiffs have failed to prove by preponderance of the evidence that the premises herein were damaged beyond ordinary wear and tear. So aside from that $11.70 for the refrigerator, all the other physical damages, the court is ruling that they were basically just normal wear and tear, which are not recoverable out of the security deposit. All right. And then she gives her formal ruling here as to the First Amendment complaint, which we've already covered in paragraphs 1 and 2. I'd be interested to hear your thoughts. And if you have any questions on that portion of the judge's ruling in the chat, so let me know. But let's go ahead and move on to the judge's ruling as to the tenant's counterclaim against the landlord. And that starts in paragraph 3. All right, as to count 1 of the amended counterclaim herein for breach of lease, the court finds that the defendants have proved the allegations therein by a preponderance of the evidence in that the plaintiffs violated and breached the addendum to the 2021 to 2022 lease by not providing a written lease to the defendants for the 2022 to 2023 lease year. So let's pause here. So the court is finding that the landlord breached the lease agreement by not providing a new lease, a new one-year lease that would run from 2022 to 2023. This part of the ruling, I disagree with on a legal basis, and we will be filing a motion for rehearing on this issue. Here is why I disagree with the court's ruling here. There is something in law, there is a theory in law called the prior breach doctrine. And in any contract, including a lease, when one party to the contract breaches that contract, that breach relieves the other party, the non-breaching party, from having to continue to perform under the contract. So whoever breaches first, that enables the non-breaching party to stop performing under the contract. It's a well-known theory of law supported by case law in our state here in Florida. At the time that the first one-year lease was ending and it was time for the parties to sign the lease for a second year from 2022 to 2023, at that moment in time, the tenant was in breach of the original lease. She was in default of 3 months worth of rent payments. So at the time she's asking my client, hey, there's an addendum that says you need to sign a new one-year lease with me. At that moment in time, she was 3 months behind in rent, meaning she had breached the contract. Because she was in breach of the contract, by law, that relieves my client from the obligation to continue to perform his obligations. And one of those obligations was to sign another one-year lease with the tenant. My argument is he wasn't required to sign another lease because at that moment in time, the tenant was already in breach. I don't think that was fleshed out enough at trial. So what we are going to do is file a motion for rehearing. And what a motion for rehearing is, they're very difficult because what a motion for rehearing is it's saying, hey, judge, I see your ruling here. I see what you did. However, I think you're wrong. So can you please change your mind? So as I'm sure you can guess, it is very, very, very difficult to prevail on a motion for rehearing Because judges, like any human beings, don't like to admit they're wrong. And it's very hard to convince, again, any human being that they are wrong. And, this judge listened to the evidence. She knows the law. She reviewed the law. And this was her decision based on her application of the evidence to that law. And I'm going to come in here and say, you know what, Judge, you got it wrong. And here's why. I typically don't file motions for rehearing because they are so difficult, because judges typically don't want to admit they're wrong and completely change their ruling after a full trial. The reason we're doing it here, number one, it's because I advise my client of these facts and the risks, and my client wants to move forward. But the reason we are filing it here is because, in my legal opinion, this is such a clear issue of just applying the facts to the law. The facts are not disputed. The defendant does not dispute that she was behind in rent by 3 months when she asked the landlord to sign a new lease. The fact that the landlord did not sign a new lease is not disputed. Those facts, in my legal opinion, require the result of applying that prior breach theory, which means the landlord is not in breach for not signing a new lease. So because it's so clear cut and black and white, which is kind of silly to say when we're talking the law, we're going to zero in and just focus on that one issue, and we'll see. Worst case scenario, the client spends, a few $100s on getting the motion filed and it's denied, but I think it's worth a try, because if we prevail on this, it's going to net about a $30,000 additional income to my client. So what I mean by that is the judge's ruling on this issue cost my client $9,166. So if she reverses her decision just on this one point, that's an additional $9,000 my client would be awarded. On top of that, we have the issue of prevailing party attorney's fees. So because this issue was decided in favor of the plaintiff, or of the defendant, of the tenant is going to be entitled to prevailing party fees on that issue. And the tenant's lawyer already said, hey, we're going to request $25,000 in fees. So $25,000 plus the $9,000, that greatly changes. So for the risk of a few $100s, that could greatly change the outcome here. So I will definitely do an updated stream on that issue once a decision is made on our motion. But that is the breach issue that was awarded in the counterclaim. So let's talk about what the court awards as damages for this breach. As a result of this breach, beginning in March 2022, without a valid lease, a copy of which needed to be presented to the management association, the defendants lost the ability to gain access to the rental unit through the residence gate by use of a device, and instead were forced to gain entrance by going through the non-residence access process, which obviously created a daily time inconvenience of varying amount, depending on how many other vehicles were seeking entrance at the given time and how many times the defendants left the development and sought re-entry on a given day. Additionally, the defendants were denied as well the use of all the other rental amenities, including the party room, gym, pools, jacuzzi, basketball and tennis courts, and tot lot. So as a result of the landlord's breach and not signing a lease for that second year, the tenant couldn't use the resident access into the community, and she was unable to access the community amenities. On March 8th, defendant's attorney wrote a letter to plaintiffs pursuant to Florida Statute 83.60, informing them that they were in material noncompliance with Florida Statute 83.51, further informing the plaintiffs that the defendants were going to withhold $833.33 per month, with the balance of the $2,500 rent payment, $1,666.67, being placed in a separate escrow account until a signed lease renewal at the addendum agreed upon rental price of $2,500, including the current same lease terms, was provided. Demand was made for the violation to be remedied within 7 days. However, no lease was ever provided to the defendants. The court finds the noncompliance to be material. That was a lot, so let's break it down. When either party to a lease violates the lease, other than not paying rent. So non-payment of rent is its own special category of breach. If there's a breach separate and apart from the rent, a 7-day notice is required. And here a 7-day notice was provided. Now, our position at the time, and our position still, when we received the 7-day notice was that we are not in breach because the tenant was in default of her rent payments at the time the second lease was to be signed. Additionally, the tenant's attorney, when requesting a new lease be signed, demanded that the $5,000 security deposit be applied to the unpaid rent, meaning they weren't offering to sign a new lease at the same terms of the first lease. They were offering to sign a new lease with different terms, namely, you're forfeiting your right to security deposit. My client said, no, we keep the security deposit in place. You catch up on your rent, and then we'll sign a new 1-year lease. That wasn't agreed to. The court doesn't seem to be persuaded by that argument, but that is what we have here. So as far as damages, the court further finds the monthly sum of $833.33 being withheld from the rent pursuant to this material noncompliance was reasonable. And defendant shall have no liability to plaintiff for the withheld amount of $9,166.63, which further constitutes adequate damages for the breach. Now, this is interesting as well because on cross-examination, I did ask the tenant, I said, how did you determine that $833.33 was the amount that you would withhold for not being able to access these amenities? And she's like, well, I just felt like that was fair. And I said, so it was based on your feeling? And she's like, yeah, I just felt that that was fair. I said, so you didn't do any research. You didn't look at the monthly HOA fee. You didn't look at or approach the association to see what part of the HOA fee was for the use of the amenities of the community. No, I just felt like that was a good number. Apparently that was enough for the judge because she agreed. So apparently the feelings of the parties are evidence at this point. So I'm joking for the most part, but all right. So as to count 2 of the amended complaint herein for return of security deposit, the court finds that the defendants have only partially proved the allegations therein, and as such are entitled to judgment in the sum of $2,185.02. So this is just the difference in what the court awarded the plaintiff from the security deposit. And she explains that here. So the security deposit was $5,000. She awarded $2,814.98 to the plaintiff. So therefore, the defendant gets the balance returned back to her, which is $2,185.02. The judge formalizes this ruling in the next few paragraphs, and the court reserves as to the entitlement to costs and attorney's fees herein. So let's talk about the implication that this ruling has on attorney's fees, which is going to be interesting. All right, so there is a prevailing party attorney's fees provision at play here, and it's found in 2 places. Number 1 is in the lease agreement itself. Number 2 is in the Florida statutes. What that means is when you go to trial, the party who wins gets their attorney's fees paid by the party who lost. Well, here, as you have seen, we have a plaintiff who partially won and partially lost on his claims, and we have a defendant who partially won and partially lost on her claims. So what happens with prevailing party attorney's fees? A long, drawn-out, expensive legal battle is what happens. So what the law provides is one of 2 things can happen. One is the court can determine which party was like more of a winner than the other. I think we won more than they won, but I think it's close. So the court can look at everything from like a big picture standpoint and say, all in all, the plaintiff won most of what they were asking for. So plaintiff gets their fees paid by the defendant. The court could also decide the opposite. The defendant won most of what they were asking for, so defendant gets their fees paid. That's one thing that can happen. The other thing that can happen is the attorneys, in any award of attorney's fees, the attorneys have to produce their time records so that the court can determine whether the attorney's fees charged in the case was reasonable. Because a party can only ever recover reasonable attorney's fees. And so a judge has to go through time entry by time entry and determine whether each time entry was reasonable. Each motion drafted, each, email, each call with the client, each hour spent on legal research, those sorts of things. In a case like this, where you have two parties prevailing on different parts of the case, the second thing that could happen is the court will have to parse through the time records of the attorneys and determine how much time plaintiff's counsel, me, spent on the specific claims that plaintiff prevailed on, and they're entitled to that. And then how much time the defense attorney spent on the specific claims that the defendant prevailed on, and they're entitled to that. I think it's pretty close to 50-50. I think we're more of a winner than them based on the numbers. We were asking about $29,000. We got $19,000. The security deposit was $5,000. We got $2,800. They got $2,100. But I think it's pretty equal. So I think the best case scenario is the parties just say, this is a wash. Let's not fight about attorney's fees because it's probably going to come out equal. Defendant wants to fight about attorney's fees, so we're going to fight about attorney's fees. And that's something else that I will keep you updated on. So takeaways, lessons from this. The content and the timing of notices when it comes to landlord-tenant issues, disputes, is very, very, very important. If you don't do your notice right, if you don't do your notice on timely, you don't get the relief. You don't get the security deposit or the damages that you're seeking. The language of the lease is very, very, very important. Make sure lease agreements are drafted by attorneys, not real estate agents, not lay people who are neither real estate agents nor attorneys. Make sure they're drafted by attorneys. This was not a very well drafted lease, which I believe contributed to many of the issues present here. That addendum never should have said the parties agree to sign another year. What if the parties hate each other by the end of the first year? Maybe no one's technically in breach, but they just can't stand each other. It's not a good idea for many, 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 many reasons. And if you are going to include that language, a lot more specificity and parameters needed to be included so the parties knew exactly how it should be handled. If one party is in breach at the time it's time to sign a new lease, does a new lease still have to be signed? I'm saying no because the law provides that, but the parties could have agreed upon that up front and put it in the contract, so there would have been no question, no argument. So those are the two biggest takeaways. The third big takeaway is literally anything can happen at trial. No matter how strong you think your case is, no matter how strong your attorney thinks your case is, weird things can happen at trial. And judges can do things and make decisions that you would never expect them to make. So litigation is risky. So just something to keep in mind. I had fun with this. I hope you guys did too. Let me know what other kind of cases you want me to go over. I'm going to continue posting the shorts with the little, legal nuggets and practical tips that you all can use to make sure you're protecting yourself and you're avoiding the nightmare that litigation is oftentimes. But I am going to be going through and doing some coverage of some other lawsuits and cases that I'm involved in, or that just are kind of prevalent in the real estate industry. And I think you all should know about and can benefit from. But let me know in the chat, comment on my videos, what content you want to see. Make sure to support my brand new baby channel and subscribe, hit that notification button. And I appreciate you guys. Have a great weekend.